start. We've got, first of all, on the agenda, apologies, please.
Yes, thank you, Chair. We have received apologies from Councillors Jack Abrahams, Robert Pritchard, David Smith, Paul Snape and Jill Waring. Apologies, David Smith is with us. I've just realised. Apologies. Paul Snape and Jill Waring, thank you.
Yeah. And I understand that she did say at the meeting yesterday, Caroline Trowbridge, who's the new member, hasn't quite completed the training with family problems.
That is correct, yes. So we will put in her apologies for today as well, because she does need the training. So yes, she's on the panel, but not
Chairman, could I just mention that at the training last week, Caroline Trowbridge was there, and in the middle of the training session, her mother died. And so I think that was a fair reason for her not completing training. Yeah.
Yes, I wasn't going to go into depth about it, but you are correct. Okay, shall we move on to item number 2, which is declarations of interest. Have we any? No. And item number 3 is the minutes of the meeting held on the 10th of November. Now, yes, that's fine. I was going to say, was I there? But it's a 10 mark when I was here at that one. There's one I had to miss for unavoidable reasons. I'll just sign these minutes and then we're done. Okay. Thank you so much. And moving on to the definitive map modification order backlog. Heather, please.
Thank you, Chair. Good morning, Chair, Vice Chair. This report is to update panel on the current position in respect of the backlog of undetermined definitive map modification order applications and directions from the Secretary of State, together with an update in respect to the later stages of the process. As you can see from the report, the county still has a significant backlog of undetermined applications, currently 281, including 52 on which the county has been directed by the Secretary of State to determine within a specific time frame. We understand from the Secretary of State that there are further 4
Could you speak a little closer to the microphone?
Sorry, can you not hear me?
I can't hear in my magic hearing.
Is that better? Is that better? Okay, thank you. So, as you can see from the report, the county still has a significant backlog of undetermined applications, currently 281, including 52 on which the county has been directed by the Secretary of State to determine within a specific time frame. We understand from the Secretary of State that there are further 4 direction applications pending a decision. The Council also has a backlog of 77 determined applications for which a modification order needs to be made and published for each of those applications. So since 2017, the Council has received 151 new applications and has been directed by the Secretary of State in respect of 167 applications. It has determined 117. These figures are set out in the table on page 2 of the report, which shows a breakdown of those figures for each year since 2017. What the figures show is that the county has received a considerable number of new applications since then, in particular during the period 2020 to 2022. And so the trend in recent years has seen more new applications than determinations, with the exception of this year, 2023, which so far has seen a reduced number of new applications. And so this year, the county has determined more applications than it's received. However, the backlog does still remain high. The number of directions received was very high for the period between 2017 and 2020, although this number is reduced over the last 3 years. During the last 3 years, the county has determined more applications than directions received, and so the number of directed applications has decreased over the last 3 years and continues to reduce. That said, there is still a considerable backlog of outstanding directed applications still to be determined. Also set out in the table below are the figures for each year in respect of the making of the definitive map modification orders resulting from determinations, together with the number of appeals against refusal to make an order and the number of contested orders, many of which are yet to be concluded and some of which may result in public inquiries. The report, which was presented to the panel on the 23rd of June, proposed 3 new measures to assisting in reducing officer time spent on application process, and these are set out at paragraph 27 of that report. The first of those measures was an increased use of delegated powers, which was to be introduced with immediate effect. The delegated powers currently in place only allow for those matters which the local county councillor and the Director for Economy, Infrastructure and Skills consider to be appropriate to be dealt with by way of delegated powers, which would generally amount to non-contentious applications. Since June, there's only been 1 application which has met that criteria, and so only 1 decision has been taken using those delegated powers. The second and third measures were to be implemented once the processes involved were considered to be sufficiently robust. Those measures being resolution of applications by alternative means, and the use of digital solutions for application packs and informal consultations. Work is still ongoing in respect of both of those measures, and I will report again on those in the next update. Thank you, Chair.
Thank you. Do you want to say anything, David? Just slightly, a little bit more clarification for me. You said there was 77 determined applications that needed to be sort of signed off, I think, basically. What's the situation there? Because it's almost like low-hanging fruit if they're determined.
Once an application is determined, if the determination is that an order needs to be made to add the route to the definitive map, then we need to draft that legal order, publish it, and then that can be objected to, and that can then be sent to needs to be submitted to the Secretary of State, and they may hold a public inquiry. So there is still a right of appeal against that order once we've made it.
So apologies for sort of picking up on it. So is that a convoluted process, or is it something that's fairly standard that can be done? Is it a resource issue there?
It is a requirement that we have to do this by law. So we have to make the legal order. It is quite a convoluted process. The actual making of the order and the publishing of the order is reasonably straightforward, but because the area of work is actually extremely contentious, the likelihood is that the order will be objected to. If it is objected to, then that will be submitted to the Planning Inspectorate on behalf of the Secretary of State. Planning Inspectorate then decides how they will determine that, which could be either by written representations or a public inquiry or hearing. Either way, we have to participate in that process. So we will have to prepare and attend public inquiry if it's a public inquiry. Once it's been heard, the Secretary of State will then, or Planning Inspectorate will then make the decision on behalf of the Secretary of State as to whether or not to confirm that order. Right,
okay. So it's not as simple as it sounds.
No.
Okay. And I think the final one for me, just as chair, there's a lot of applications we've still got to hear, and a lot of historic applications. I presume this is in the main part a resource issue.
Yes, that's correct, Chair.
Right, okay. I think it might be sensible for David and I to have a word with the Cabinet member. I presume it's Victoria Wilson, sorry. If perhaps that could be arranged by yourselves or Joe, I think that would be a sensible thing.
Yeah, we'll speak to Joe after the meeting and get that arranged.
Brilliant. Thank you so much. Do you want us, David?
I was only going to say that Victoria Wilson is in the building at the moment.
Okay. Perhaps we'll be able to catch up with her and just sort of arrange a meeting at some point. But I think it's something we need to sort of keep flagging up that we have got this historical backlog As with many other councils in the country, it's not something that's specific to Staffordshire County Council. Okay, thank you very much for your report. And we'll move on, please, to item number 5, which is the application to upgrade public footpath number 18, Quornford, to a restricted byway. And I understand Hannah's taking this one.
Yes, thank you, Chair. So as stated, this is an application to upgrade public footpath 18 in the parish of Quornford to a restricted byway. A copy of the line of the route can be seen at Appendix B. The application was submitted by Staffordshire Moorlands Bridleways Group and was submitted based on historical evidence. The original evidence submitted consisted of a 1929 handover map for the parish of Quornford. So if I deal with the evidence first. So the 1929 handover map shows a route running along the same line as the alleged route and is coloured turquoise. There is no key or list with the map, so no indication as to the status of the route. Under the Local Government Act 1929, the responsibility for publicly maintainable highways was transferred to county councils from district councils. This led to lists being created which recorded the routes that had public maintenance liability, and these became known as handover maps. The term unclassified county roads came to be applied to these routes. This moniker has no legal status, however. The handover map is only concerned with liability for maintenance, not with the type of public user. This document specific to the application only supports the route's physical existence as a public right-of-way, as it shows liability for the route, but it does not attest to the nature of the public rights. Officers obtained the parish survey card for public footpath 18 Quornford. The path symbol for the route is FP, denoting that the route was considered to be a footpath. However, the acronym CRF is also written, but it appears to be crossed out. The description of the route in the parish survey card refers to a footpath, and there is nothing to indicate that the route has been used by vehicles. The acronym CRF could suggest that the route was capable of being used by vehicles, but in light of the fact that it appears that the acronym has been crossed out and it also states FP, and the description only refers to a footpath, the parish survey card overall does not support the contention that the route was used in any other way than as a footpath. When we consider evidence submitted by landowners, one landowner was identified on submission of the application. The landowner advised that they used the land for agriculture. They also advised that signs had been put up by Peak Park 20 years ago stating no cyclists, walkers only, and these signs are still in place. Staffordshire Moorlands District Council advised on submission of the application that they had no evidence to submit in relation to the application and they had no objection to it. Quornford Parish Council responded to the application advising that they were against it. They advised that the path goes through a yard which is used for stone breaking. They also advised that the condition of the path would require considerable expenditure to upgrade. A local volunteer ranger had also done a history of the area, and they advised that there was a possibility that the route may have been used for transporting coal in the past with pack horses and carts, although that was unlikely due to the inhospitable terrain of the area. The Open Spaces Society advised that they had no evidence in relation to the application, but they supported it. The British Horse Society also advised that they support the application. Correspondence was also received from a member of the public objecting to the application. They advised that the route is peaty and boggy with long areas of long-standing water, along with the path being narrow and fragile in parts. Whilst it is not our intention to belittle any legitimate concerns raised, the courts have decided that issues relating to safety, security, privacy, suitability, future maintenance and wildlife concerns cannot be taken into consideration. Only evidence regarding the existence or not of a public right-of-way can be taken into consideration, as this application is submitted based on historical evidence. Following circulation of a draft report, the applicant submitted further evidence, including an enclosure award dated 1839, further documentation relating to the 1929 handover evidence, and an ordnance survey map dated 1953. The enclosure award shows the eastern section of Quornford Public Footpath 18, and it is depicted on the map as a route called Stone Pit Road. The section of route is depicted as a carriageway and falls under the section of the award, Carriage and Drift Roads. The text refers to the owners and occupiers being responsible for maintenance of the route and the route to be used for people using the adjoining lands. This would indicate that the route was considered to be private rather than for the public at large. The entirety of the route is not shown in the award, and the route depicted on the map does not connect to another highway to the north. It appears to stop in the middle of a field at a stone pit as described in the award. As the route does not connect to a highway at both ends and it appears to lead to a parcel of land, this would suggest that the route was private for people needing to access the land. The text also refers to maintenance of the route by way of a general rate of assessment. This would have been a levy placed on each landowner depending on how much land they owned. The award supports the contention that private vehicular rights exist up to the point and along the stretch of the route depicted in the enclosure award, but not for the entirety of the existing route. The ordnance survey maps that were submitted show the physical existence of the route, and when viewed alongside the key with the maps, they do support the alleged route being an unmetalled road, unfenced road, or a minor road. When we consider the relevant legal tests, what is not in dispute is the fact that the route is a public highway. The question relates to the status and nature of the public rights over it. The evidence needs to be considered on the balance of probabilities as to whether the evidence shows the existence of a restricted byway over the alleged route, and therefore that the current classification of the route as a footpath is wrong. To summarise, none of the pieces of evidence submitted in support of the application are evidentially strong on their own in supporting the route's existence as a restricted byway. Therefore, to conclude, when all of the documentation is reviewed together, it does not support the contention on the balance of probabilities that the route should be reclassified to a restricted byway. Therefore, Officer's recommendation is to reject the application and for no order to be made to upgrade the route to a restricted byway. Thank you, and I'm happy to take any questions.
Thank you, Hannah. That was a very concise report, as usual. David, do you want to make any comment?
A very comprehensive, very clear report, Chairman. I'm perfectly happy to move the officer recommendation.
And I'll agree with you on that one. So we'll therefore agree with the officer's recommendation to refuse. Thank you very much. And we'll move on, please, to item number 6, which is the application for the addition of a byway open to all traffic from Clay Alders Bank to footpath 62 at Eccleshall. And I understand this is you, Becky.
It is, yeah.
Thank
Thank you, Chair. So, as stated, this is an application for the addition of a byway open to all traffic from Clay Alders Bank to footpath 62 Eccleshall. The line of the route can be found at Appendix A to the report. I can confirm that we received no objections or representation from the local member. This is an application that was submitted by Mr. Martin Ray, and this application is based on historical evidence. The applicant provided a copy of the 1910 Finance Act Increment Duty Value Duty Plan. The alleged route is shown as being separate from the surrounding land holdings and terminating at a plot of land. It does not meet with any other highway at that point. Consequently, it is possible that the route was private and used by a number of people for accessing land. The applicant did not provide a copy of the field book, and your officer has not been able to locate a copy. Without a copy of the field book, it is unclear if the landowner did claim tax relief on this particular parcel of land. Whilst the deduction entry would not have described the route, it may have provided evidence of its existence and status. However, As the route is shown as separate from the adjoining land holdings, it is not likely to have been referred to in the field book in any event. The applicant also provided a Podmore tithe map dated 1838, a copy of which can be found at Appendix D to the report. Members will know that tithe maps and their accompanying apportionments were produced solely for the purpose of identifying tithable land and were not concerned with the recording or establishing of public rights of way. The route is shown clearly on the tithe map provided. However, it terminates within a plot of land and does not meet with a highway at that point, which again would suggest that the route may have been private in nature for the purpose of accessing private land. The book of reference does not refer to a public route of any description. The applicant also provided an OS map dated 1817. As members know, Ordnance Survey maps provide excellent evidence of the physical existence of features they show at the time of the survey, but they are silent on matters of status. From the 1880s onwards, the maps include a disclaimer to that effect that the depiction of any path, track or way is not evidence of the existence of a public right-of-way. The alleged route is depicted on a copy of Ordnance Survey map 1817, as I mentioned, and it shows the physical existence of the route. However, it does not infer any public status. The map appears to show the route leading from Clayalders Bank to a plot of land and is not a through route. Consequently, this does not appear to support the contention that the route had public status. Finally, the applicant provided a copy of a Teesdale map dated 1832. The Teesdale map was a commercial map, and such maps were produced in the early 1800s and were often produced to record specific activities such as mining and encroachment. The map appears to depict the alleged route as leading from Clayalders Bank, but it does not appear to meet with another highway or lead to a regional centre, and consequently this does not appear to support the contention that the route has public status. In any event, such maps support the physical existence of the route, but do not infer public status. When the application was first accepted, the landowner was contacted and a response was received. They stated at the time that the land had been in their ownership for approximately 3 years and that they were the sole freeholder owner. They informed the council that access was granted to the occupants of Burley Cottage to use the lane, but only up to the cottage itself. They did not have access beyond the cottage. A copy of this landowner evidence is attached at Appendix G. A map was also submitted by the landowner to show the extent of their ownership, stating that the land surrounding Burley Cottage was all owned by them, and a copy of that is also at Appendix G. Since the report was circulated to all interested parties, your officer has received no response for or against. The application is made under Section 53(2) of the 1981 Act, relying on the occurrence of the event specified in 3CI of the Act. The application is for the status of a byway open to all traffic, which is defined in Section 66(1) of the Wildlife and Countryside Act as a highway over which the public have a right-of-way for vehicular traffic and all other kinds of traffic, but which is used by the public mainly for the purposes of which footpaths and bridleways are so used. Under the Natural Environment and Rural Communities Act 2006, which is also known as the NERC Act, and that's in subsection 1, restrictions have been placed on the recording of public rights of way for mechanically propelled vehicles on the definitive map and statement. Section 67 of the NERC Act, subsections 2 to 8, provide exceptions to the extinguishment of certain unrecorded rights of way for mechanically propelled vehicles. One exception is if before the relevant date, which is in subsection 4, and the date is the 20th of January 2005, an application had been properly made for a definitive modification order to add a byway open to all traffic to the definitive map. This application was properly made before the relevant date, and consequently this exception does apply. If the evidence was sufficient to show that a byway open to all traffic is reasonably alleged to subsist, then it would be added as a byway open to all traffic rather than a restricted byway. So just sort of summarising, The Finance Act 1910 map shows the lane as separate to adjoining land holdings. However, it does not connect to a highway at both ends and appears to lead to a parcel of land, suggesting that this was private in nature. The alleged route also shown on the OS map and on the Teesdale map. However, both of these maps appear to show the route leading to a parcel of land, and the route does not connect with a highway at both ends. These maps show only that there was a physical feature which existed at the time, but don't provide evidence of a public right-of-way. The alleged route, which is shown on the tithe map for the area, shows the lane as separate to adjoining land holdings. However, it does not connect with a highway at both ends on this and appears to lead to a parcel of land, suggesting it was also private in nature. When the totality of the evidence is considered, I would suggest that the route is private in nature and does not suggest any specific type of traffic that would have used the route. So in conclusion, the probity of the evidence is not strong enough to prove that a right-of-way with the status of byway open to all traffic subsists. It's the opinion of your officer that the County Council should not make a modification order to add the byway open to all traffic or a public right-of-way of any description to the definitive map and statement of public rights-of-way. Thank you.
Thank you, Becky, for that. Again, a very good report. Forgetting everything else, for myself as a farmer, that does look like it's a straight line to a field, and it would suggest to me, just on the evidence in front of us, without what else the other evidence you've put in, that, as you say, it was a track to a parcel of land. So I'm quite happy to go along with the officer's recommendation on that. David?
Yeah, a very comprehensive report, and I think it deals with all the issues that we're likely to consider, and I'm happy to propose the recommendation to committee.
Thank you.
So we'll go along with the officer's recommendation on that. Thank you so much, and we'll move then, please, on to item number 7. Pen packed in, but there you go. Item number 7, which is an application to add a public footpath from Basford Lane to the existing footpath 33 in Cheddleton, and that is David. Thank you.
Thank you, Mr. Chairman, members of the panel. And again, I can confirm that we've received no representations or objections from the local member. This application was for the addition of a public footpath from Basford Lane to the line of public footpath 33 in the parish of Cheddleton. It was an interesting application and an outstanding example of the probity of legal orders in the absence of other evidence. I will move straight to the recommendation, which is that the evidence is sufficient to show that the route subsists on the balance of probabilities and that an order should be made to add it to the definitive map and statement for the district of Staffordshire Moorlands. Turning to the evidence in hand, the applicant submitted a quarter sessions order dated 1852, and it is on this singular piece of evidence that the application will succeed or fail. As such, this is a comparatively short report that clearly demonstrates the power of legal orders. Members will see a copy of the quarter sessions order attached to Appendix C along with a certificate of completion. The latter is dated 1853, 1 year later than the order itself, and as such we have all three elements of the strongest possible evidence available to us. We have the order, the certificate and the plan. Turning to the order itself, we find a well-preserved and informative document which is replete and cogent and which clearly relates to the matter in hand. We find the Reverends Sneed and Heathcote were the two appointed justices responsible for overseeing the processes involved, and it can be seen that they retained an interest right up to the certificate of completion. The order goes on to say that the justices were acting within the 100 of Topmanslow, which, as many with an interest in the county will know, was one of the 500s of the Shire. That is, one of the 5 ancient administrative areas of Staffordshire. For completeness, the other 400s were Pyre Hill, Offlow, Cuttleston and Sizedon, and members can see these details between points 17 and 21 of the report. Turning to the main body of the order, we find a Robert Clemenson recorded as the Surveyor of Highways, having been appointed by the two Justices of the Peace. He is recorded as being the Surveyor for the township of Basford in the parish of Cheddleton. Not only are the Justices and the Surveyor clearly identified, we also have the names of the relevant landowners: William Phillips, William Steeple and Edwin Heaton. The relevant plots are identified either in the order or on the plan and provide good reference points for the line of the route itself. Turning to the details of the order, which in this case is a highways diversion order, we find that both the existing route and the proposed route are clearly identified in the description and on the plan. If members would be kind enough to turn to Appendix C, it can be seen that the existing route, or the route to be diverted, is clearly marked with the letters A to B and is described as the footpath proposed to be stopped up. These words are written on the plan itself along the line of the route that was to be diverted. Members will note that it is in slightly lighter characters than the wording on the new route. The body of the order also gives an ample description stating that it commenced at a stile near Basford Bridge, being point A on the plan, and ran through or over the land of the above-mentioned William Phillips Esquire. Although the letter A is faded somewhat on the plan, it is still visible and is further confirmed by the geographic reference point of Basford Bridge and the ownership reference point of William Phillips Esquire. Members will find this towards the bottom left-hand corner of the landscape-orientated section of the plan. You will see it is in two parts, one in landscape and one in portrait. The line of the existing route is further clarified in the main body of the order as passing through a farm called Basford Villa, also shown on the plan, and terminating at a point marked B on the highway leading from Cheddleton Heath to Leek. Again, the plan could not be clearer, as it shows the highway in question annotated with the words from Cheddleton Heath in the north and to Leek in the south. Members will see this on the portrait-orientated section of the plan. So taking the two copied sections of the plan together, we have a clearly described and depicted route that was the subject of the 1852 diversion order. Now the question has to be, is the diverted route itself also shown with the same degree of clarity? Turning back to the main body of the order, we find the new or replacement route described as follows: a highway or footway from point A on the plan to point C near to a gate leading to Basford Villa, and across the Basford Villa estate to the Leek to Basford Road, marked with the letter D. Again, the new route, or the proposed footpath, as it is referred to on the plan, is clearly shown, and there can be no doubt whatever that this is the route in question. Turning to the other details within the order, we found that the relevant landowner, Edwin Heaton, had agreed to the new route crossing his land, stating that he had, under his hand, by writing, consented. This is important as the legal order process in 1852 followed a very similar pattern to that which we employ today, and the importance of a consenting landowner can do no more than ameliorate the process. The order continues with a detail of the overall processes concerned, describing what is in effect the equivalent to the informal consultations we carry out today. The affixing of a notice at each end of the footway and the placing of an advert in the press are still extant in law. Again, this order has everything. It ticks all the boxes. We have two Justices of the Peace, a designated Surveyor of Highways, an order that sets out the due processes involved, a landowner who has given his express consent, a plan that clearly shows the old route and the new route, and a certificate of completion. In addition, the metes, bounds and add measurements were requested by the Justices, and we have an interesting table of reference in the bottom corner of the plan. This sets out a comparison between the lengths of both the proposed and existing footpaths, and given, of course, in yards. As such, the lengths of both the old and new routes from Cheddleton to Leek and Bradnup were found to contain 110 yards in favour of the new or diverted route, referred to in the table as the diversion. Similarly, the lengths of both the old and new routes from Basford Bridge to Leek and Bradnup were found to contain 15 yards in favour of the old route, referred to in the table as the present footpath. Taking the two figures together, we find a total of 95 yards in favour of the new diversion. The routes from both Cheddleton and Basford Bridge to Leek and Bradnup can be clearly seen on the plan and are indicated on what appear to be the highest status roads. Although somewhat academic to the matter in hand, these calculations do show that the Surveyor of Highways had executed his duties very fully and that the exact line of both proposed and existing routes had been very carefully determined. Lastly, we learned from the order that the proposed new highway or footway will, and I quote, be more commodious to the public due to the old highway or footway being in some parts extremely rugged and dangerous on the account of the declivity through a certain wood. This was further supported by the fact that the existing route also passed over a brook and through a farm space, presumably a yard, where many dogs and other dangerous animals were kept. These latter points would perhaps not be as readily taken as supportive evidence today, as landowners are required to contain dangerous animals, which can of course be classed as a deterrent to use and therefore an obstruction. That said, these points do explain why it was felt that a diversion was necessary back in 1852 and gives context to what is already a very replete and informative piece of evidence. Turning to the Certificate of Completion dated 1853, we note that the Justices had viewed and surveyed the new footway and that it had been enrolled by the Clerk of the Peace for the County of Stafford. It had also been lodged amongst the records of the said Court of the Quarter Sessions. And if this were not enough, we have a further description of the newly diverted route and confirmatory statement that the said highway or footway is now completed and put into good condition and repair and likely to continue. The completion certificate is of course signed by both Justices Heathcote and Sneed. Mr. Chairman, what more can your officers say? We have the strongest possible form of the strongest possible evidence. As evidence goes, we have everything: order, plan and certificate of completion. Each is clear and each supports the other. Turning to the statutory consultee, Staffordshire Moorlands District Council stated that they supported the proposal, provided that the route was cleared of vegetation and obstructions and was clearly waymarked prior to public use. Although evidentially unweighted, the comments clearly show that the application was supported by the district. Following the circulation of the draft report, 2 of the primary landowners contacted the County Council to question the validity of the claim. They questioned why it was needed when public footpath 33 was in such close proximity to the route and when other routes in the area were more commodious to the walker. Safety concerns were raised at one end of the route and it was highlighted that nothing was actually visible on the ground. It was also stated that the field in question was used for stock, including calves, and that this would present a significant worry for landowners due to the public safety concerns of stock control. Again, your officers have discussed these concerns with both of the landowners concerned and have explained the legal processes involved and the types of evidence that will be needed to overturn the recommendation. Although duly noted, the representations and objections received are not material to the claim and are not therefore matters that could be taken into account by this tribunal of fact. In summation, Mr. Chairman, although the evidence is limited to a single document, your officers can do no more than to recommend that the application be accepted on the balance of probabilities and that an order be made to add the route with the status of a public footpath to the definitive map and statement for the district of Staffordshire Moorlands. Your officers further recommend that this should be to the standard minimum width of 1 metre throughout its length. Thank you, Mr. Chairman. Happy to take any questions.
Chairman, I think the report is very clear and very precise as far as we're concerned. Can I just pick up on one point where I think you said Staffordshire Moorlands were placing a condition of clearance on the site? I mean, that's clearly nothing to do with us. We are only approving the line of the footpath. We don't have any powers to do anything other than that, is my understanding, Chairman. And so, subject to, I think you want to make a comment, I would recommend that we approve the officer's recommendation, Chairman.
Would you like to comment on that point, which is quite salient?
Thank you, Mr. Chairman. Yes, it's immaterial really to the claim and the matter in hand. If members were minded to add the route to the definitive map and statement and to recommend an order was made, then this would be an issue for our colleagues in the Rights of Way team following the making of that order, should that order be successful.
Thank you. Thank you, David. Does that answer your question? Thank you. That was quite a fascinating report. It was almost as if the two justices of the peace were in the room, the way you put everything that had gone on. And for me, when it actually sort of says, you know, the Reverend John Sneed and the Reverend Thomas Henry Heathcote were responsible for overseeing the legal processes involved, it does sort of give you an idea of the responsibility we've got as a rights of way panel, because we're following on from some eminent people in the past who have put these things together. And something like 170 years ago, heading towards 200 years. So really fascinating, and the point that David's made is that we can't take the fact that there's cows and calves in the field, or bracken that's got to be cleared, whatever's got to be cleared, into account. We've just got to look at the definitive map and say what we think should happen. And this is almost like a classic case. We could sort of, I hope it goes into the training package actually, because it's got so much benefit to members to sort of go through this case. I agree entirely with the officer's recommendation, as David does. So we'll go with the officers on that one. Thank you very much. I understand there's no items for exclusion of the public, so we will, at this point, looks like it's 22:11 from this angle, close the meeting, and can I say thank you to David and the officers for the time they've put in. Thank you all.